All right, guys, I have a little bit of bad news in this video for people who are going to be filing I-130 petitions. One of my colleagues recently spoke with a USCIS officer unofficially, and the officer told him that anyone who entered the US without inspection who files an I-130 should, in the future, expect a notice to appear in immigration court. The notice to appear is the document that basically initiates your removal proceedings, your deportation proceedings from the United States. This is not an official policy yet. In fact, I'm still submitting I-130s because it hasn't become an official policy. But in the future, in the near future, we could expect some official policy changes where USCIS is going to be referring cases to immigration court. This is a pretty drastic departure from how USCIS has behaved in the past. USCIS is not known as like a deportation or enforcement branch of the Department of Homeland Security's immigration agencies. It's the agency, the sub-agency with which you would apply if you want an immigration benefit. So they're in charge of like issuing benefits, work permits, green cards, naturalization, all that good stuff. Based on what my colleague was told, we only expect people who've entered the US without inspection to receive these notices to appear. I don't know if it also is going to impact people who are currently out of status, which is probably the majority of people in the US for whom an I-130 is filed. In the past, you used to be able to file an I-130, well, not used to, you could still do this. You could file an I-130 for someone who entered the US without inspection. And then the procedure is they'll probably need an unlawful presence waiver, which is filed on Form 601A. And that takes like 4 years to get approved. If it gets approved, then we would need to schedule for the immigrant to go back to their home country's consulate, US embassy or consulate in their home country, go through the consular process, and then re-enter the US as a permanent resident. That's the procedure for someone who entered without inspection, who's the beneficiary of an I-130 petition. Now, if removal proceedings are initiated after you file that I-130, you would need to also be eligible for some sort of defense from deportation. There is some case law, court precedent, indicating that if you have an I-130 that's approved and a 601A waiver pending, the courts aren't supposed to just like deport you before that 601A gets approved, which again takes like 4 years. So basically you would go into court and the judge would ask like, what defense from removal are you seeking? And the response would be something like this. Well, Judge, we have an I-130 that's approved. We have an unlawful presence waiver, Form 601A waiver pending. The average processing time on that currently is like 40 months. So we're just seeking a long continuance. Let's keep these proceedings pending. And then at the end of that, my client's going to seek voluntary departure, in which they could depart the US and avoid a deportation order to continue with the consular process abroad. And if all goes well, they re-enter the US as a permanent resident. There have been some other variations of how this has played out in the past with different administrations. For example, sometimes we were able to just administratively close removal proceedings where it's not even an active removal case anymore. You don't need to just seek a long continuance and then seek voluntary departure in the future. There have even been times in the past where we've been able to terminate removal proceedings just based on a 601A waiver. But the last time Trump was president, and this really happened towards the end of his first presidency, the second 2 years is when he really implemented a ton of immigration changes, the Department of Homeland Security would begin opposing administratively closing cases. And actually, Jeff Sessions, who was the Attorney General briefly, implemented a ton of changes where judges even lost the ability to administratively close cases. And so in more liberal immigration courts, such as New York, the judges had to come up with like creative solutions for not deporting these people who are gonna be eligible for a green card, hopefully like within a few years. And it varied from judge to judge, but many judges would just allow you to seek a long adjournment in the case, drag it out, and then eventually you would be able to depart the US without a deportation order, to go through the consulate and re-enter the US as a permanent resident. Anyway, people right now are really panicking, understandably. I mean, there have been a lot of terrible changes to the immigration policies. Even for legal immigrants, people who've done it the right way are still in fear, and I understand. It makes sense. Honestly, like if you're a permanent resident, the fear and the dangers are probably overstated. Most permanent residents are at no risk of being removed from the United States, at least currently, based on all the information I have and all the cases I've seen where people were targeted. It's such an infinitesimally small percentage of people. But other people who, for example, someone who entered the US without inspection 20 years ago, never committed a crime, has US citizen children, and is now married to a US citizen spouse, the next logical step would be for the US citizen spouse to file an I-130 petition for his immigrant spouse. And if you do that, after this proposed policy change actually takes place, the immigrant spouse might very well end up in deportation proceedings. So before you file the I-130, it might be a good idea to speak with an attorney about what possible defenses might be available to you in the worst case scenario if this rumor actually becomes reality and this policy is implemented, which, you know, it's not a far-fetched policy. I think it's very likely to go into effect sometime this year. So it's just good to be informed and create a plan B and a plan C in case it comes to that. All right, guys, that brings us to the end of today's video. Sorry to be the bearer of bad news, but I really do believe that this is going to happen pretty soon. So if you're considering filing an I-130 and you entered the US without inspection, it's a good idea to speak with an immigration attorney. If you yourself need any immigration assistance, whether you're filing a petition, applying for a green card, applying for naturalization, or find yourself unfortunately in removal proceedings after receiving a notice to appear, you can consult with me. I'd be happy to assist you with your case if it's a good case. Otherwise, I'll tell you what the risks might be. If you're new to my channel, I create several videos on a weekly basis on these topics, and I specifically focus on changes that the Trump administration is implementing. But when I run out of enough stuff to talk about with that, which has not happened yet, I focus mostly on family-based immigration and naturalization. So if you're interested in those topics, be sure to subscribe, and I'll see you guys next time for another video.